Hey everybody, Ben Keck with Keck Legal here. Today we're going to talk about something that I see, a question that I get all the time, which is, can a business owner be liable for business debts, personally liable? This is something that is a constant question for business owners who oftentimes will have an LLC, but perhaps they're wondering, do I have personal liability for some of these debts, or can I just potentially walk away scot-free? Do I need to look at restructuring? Do I need to look at seeking bankruptcy protection? And let's talk about that. So first of all, let's paint the picture, right? And this is a very typical scenario. We'll use something very basic. We've got a single member LLC with one owner. All right. Let's say you started a business, you set up an LLC, you did all the right things. You've got your LLC, ABC LLC, you've gone out and you've borrowed money, you've got some loans, you've got some business credit cards, you've got some trade debt, maybe you've got some suppliers, maybe you've got some independent contractors. And so there's all these business debts. The question now, maybe there's taxes that are owed, right? Now there's all these business debts. And the question now becomes, okay, if can I just put the LLC into bankruptcy and walk away? And the answer to that, of course, is it depends. It depends on a lot of things. Most notably, what is the debt? What's the nature of it? And did you personally guarantee it? And this is something that you need to be constantly vigilant for. In any documents you're ever signing is a personal guarantee. So you set up your LLC, which is a smart thing to do. Hopefully, you got a lawyer to help you with that to make sure you did it correctly, the right way, and that you're fully protected to the maximum extent you can be. Once you've done that, okay, you have that protection, but there are certain exceptions where you might not be protected. And of course, the reason you set up the LLC is to protect yourself from personal liability, but now we've got a few exceptions to that. So presumably, most of the business debts, uh, sure, with certain exceptions, sure, you could put the business into Chapter 7, wipe out the debts, except one, if you've signed a personal guarantee. And any loan with any bank, they're almost certainly going to require you to sign a personal guarantee. As a small business owner, single member LLC, there's no way that any bank is giving you a loan without you personally guaranteeing it and probably pledging some collateral, possibly giving a lien on your house, which now you've taken on significant additional risk if you've done that. Any credit cards, any business credit cards, almost certainly any credit card company is going to require a personal guarantee, and it's going to be there in that document. And I have so many clients that come to me and I ask them, hey, did you sign a personal guarantee? And they don't know. They don't remember. People don't know what they're signing and don't realize how much risk they're taking on. If you just signed a loan document, a credit card agreement, a lease, landlords will put this in this. I've seen this with trade creditors as well. You might have a supplier that's selling you products and they might slip a personal guarantee into their account agreement. And once you signed it, you have basically now waived any protections that the LLC gave you. So now, if, God forbid, things go wrong, can't afford to pay, the company can't afford to pay its bills, you can't just walk away from the debt you've personally guaranteed. Now, anything where you didn't personally guarantee it, probably you can walk away from that. Somebody sues the company, doesn't sue you personally, or maybe the company just owes somebody money for work done, but there was no contract. Most of your basic debts, sure, that could get wiped out if the LLC, if you put the LLC into Chapter 7 and decide you just want to walk away. But any personally guaranteed debt, it's basically the same that as if you had taken that on personally. It's almost as if the LLC didn't exist. Now, of course, the LLC is the main borrower, you're just the guarantor, but if the LLC doesn't pay, immediately they're going to sue you on the personally guarantee. And you better respond to that lawsuit, because if you don't, what's going to happen is they're going to get a default judgment. If you just ignore the lawsuit, they'll get a default judgment on the personal guarantee. Now, once they've got a judgment, now they can file a lien on your assets, your home, garnish your bank account. You wake up one morning and your bank account's empty. If you ever find yourself in that situation, you need to talk to a lawyer immediately. You should never, ever ignore a lawsuit. That is a huge, catastrophic mistake. Anytime you get a notice of a lawsuit, you should talk to an attorney immediately. So back to talking about personal liability for business debts. We've talked about personal guarantees. That's a huge issue you need to be absolutely hyper vigilant about because you've now accepted personal liability for those business debts. Another big one is certain things that are going to be you're going to be personally liable for no matter what for business debts. The big one is taxes. Payroll taxes and sales taxes in particular are what are considered trust fund taxes. And what that means, with the way the government and the law views that, you are, for example, let's take withholding taxes. Okay, you are withholding taxes from your employee's paycheck, and then you're required to turn that money over to the government as an employer. Well, guess what? The way the government sees it is that is not your money, that you are required to turn that over. And if you don't, as a responsible officer of the company, you can be personally liable for payroll taxes. Another big one is sales taxes. Same concept. You send a customer a bill for some product, they pay it. Oh, you didn't pay the sales tax. Well, guess what? The way the government sees that is that was never your money. You were just holding that money in trust. You were supposed to take it from the customer to the government. And if you failed to do that, you can now be personally responsible for those taxes you didn't pay. And failing to pay taxes is one of the absolute worst mistakes that you can possibly make because they're the last people that are going to come after you because they know that you're going to have to pay. Most of these tax debts like this are going to be non-dischargeable in bankruptcy. Quite a few tax debts are non-dischargeable. Even if you file a personal bankruptcy case, it still might not matter. You still might have to pay these taxes. So that's something to be very aware of, that when you're dealing with tax issues in a business, that if you're not paying the payroll taxes and the sales taxes, you are taking on enormous personal risk of that you would be very wise to not do and find some other option, talk to a restructuring attorney and figure out, hey, what should I do here? And it's so sad. I see this all the time where almost every client I see, I really wish they'd come to me 6 months ago or a year ago. It's the last thing people want to do is talk to a lawyer. I don't like talking to lawyers. Who wants to talk to lawyers? But I got to tell you, it's a huge, huge mistake not to. It's you're absolutely in treacherous waters. Anytime you're starting to get behind on any bills, any taxes, you absolutely ought to talk to a lawyer immediately to know what your options are. So back to potential non-dischargeable debts, potential personal liability. So we talked about how you can be liable for business debts. One, we talked about personal guarantees. You signed a personal guarantee. That's now personal debt also, in addition to being a business debt. Taxes, that you failed to pay trust fund taxes. You could have personal liability as a responsible officer of the company. Another way you could potentially have personal liability is for anything, any transfers out of the company. For example, um, you paid yourself back a bunch of money or transferred a bunch of money to a family member, another member of an affiliated, maybe you have an affiliated LLC. Oh, I've got this LLC over here. Like, oh, I'm just going to transfer some assets over there. Well, guess what? That's a textbook fraudulent transfer. And there's been laws on the books for hundreds of years that say if you do that, your creditors or a trustee, if you file bankruptcy for your first LLC, can now go sue the other LLC for and basically unwind it, claw that back. And we see this a lot with transfers to family members. Oh, the classic case of a fraudulent transfer is husband gets in trouble with creditors, is worried about potential liabilities and creditors coming after him. Oh, I'm going to sign over the deed to the house to my wife and get it out of my name. Well, that's slam dunk. That's getting, not only is that getting unwound, you're now going to be accused of being a fraudster and having people suggesting that you are that perhaps none of your debts should get discharged. So anything where creditors can accuse you of potentially fraudulent activity, even with respect to the business. So let's say you transferred a bunch of assets out of your business and then just walked away, and now you need to file personal bankruptcy. Well, guess what? If that's within 1 year of your bankruptcy filing, you now lose your right to a discharge, which means none of your debts get wiped out. I mean, it is an absolute hammer, absolutely critical that one, you be aware of this, and two, if you're talking to an attorney, if you're talking to a bankruptcy attorney, make sure you tell them these things. If you're not sharing this information with your attorney, you are making a crucial error, because if you hire somebody who files a Chapter 7 case for your business and you didn't tell them, or for a personal Chapter 7 case, and let's say you just shut down the business and you didn't tell them about these transfers, and you file the case, now a trustee gets appointed, and now there's an investigation into your activities. And if you haven't done everything all the right way, you lose your discharge. In that situation, like I mentioned with the 1 year look back period, probably if you had waited a year and a day, if you had told your lawyer, hey, there's this transfer that you need to be aware of, first thing I'm going to ask is, what was the date? When did that happen? All right, let's mark our calendars for a year and a day. At that point, maybe it's not an issue anymore. So these are the kinds of things that no one other than somebody who does bankruptcy law is going to know about. But these are the things you need to know about and be aware of. Potential personal liability in terms of not getting debts discharged. So that's something you definitely need to be aware of when you're doing certain things with respect to your business. If you could be accused of some sort of fraudulent activity, transferring assets, whatever, that can now put your personal discharge at risk and essentially translate into personal liability. And certainly also if someone accuses you of any sort of fraudulent type things, and this happens all the time, where some creditor is mad. It especially happens when you've got a business partner or a former spouse or someone who maybe used to be a friend, an investor, who, it's not a big company, it's just a person who's out a bunch of money and is very unhappy about that. And now they believe you've committed fraud, and they might be totally wrong about that, but they might still come after you for that and make those sorts of accusations. So if you find yourself feeling like you might wind up in a situation like that, you absolutely should talk to an attorney immediately and know your rights and know how to protect yourself. So in sum, when we're talking about personal liability for business debts, a few things you definitely need to be aware of. First and foremost, personal guarantees. You definitely want to be very aware of any personal guarantees you're signing and know what you're signing. Number two, tax debts. You do not want to get behind on tax debts, especially payroll taxes and sales taxes. And number three, be very aware of the possibility of any of your creditors who might accuse you of transferring assets or doing anything that could be construed as fraudulent activities or misrepresentations that now they might try to translate into a claim against you personally and try to prevent not only your debt to them getting discharged, but all of your debts personally getting potentially discharged, which is a huge risk you need to be aware of. So how do you protect yourselves from these situations? You got to talk to an attorney. This is nobody other than a professional is going to know all these things. So you need to have someone in your corner who's able to properly advise you, and the sooner you talk to somebody, the better, because if you wait too long, the die may be cast. If you already made the transfers, if you already didn't pay the taxes, if you already signed the personal guarantee, it might be too late at that point, and all we can do is mitigate the damages. So the sooner you talk to an attorney, the better. So would love to get you in here and talk about your situation.